Trusts have been around for a long time. The earliest trusts go back to the Roman era, in sort of in BC times, right up to the beginning of the AD times. In Roman civilization, only a male Roman citizen could inherit property. And to be a Roman citizen, your mother and your father had to also be Roman citizens. And imagine this is a time where Rome is out conquering the world, and so you had a lot of children born from marriages and unions that weren't a Roman mother and a Roman father. So what was a Roman citizen to do if it turned out their son, or heaven forbid their daughter, right? Because women were not able to inherit property in those days. If that was your heir. So they created some of the first concepts where the property would be left to a Roman citizen to be held for the use of the non-Roman person. And those were some of the earliest trusts. But our modern day trust sort of dates back to 1,000 years ago, to the era of the Knights Templar. And it's interesting that becomes such an important milestone in the development of trusts. So you had these wealthy families, you had the king, you had the princes, the nobles, sending off their young men to fight in the Crusades, to go and liberate Jerusalem for Christendom. And the island of Malta became this sort of staging area. I'm sure you've all heard of the Knights Templar. They were not only the soldiers, but essentially they became the bankers to the European kings. So the kings would provide them with money, and they would use it to provide weapons and things like that on the troops going over to Jerusalem. And then they would also, they set up the first really large hospitals in Europe, and they would care for the ones that didn't make it back all in one piece. And it's interesting that the King of England during this period took on more debt than he could afford to pay. Something we can all identify with in today's era, where governments can spend more than they bring in. And so you actually had the first legal case where some creditors of the king went to Malta and said, wait a minute, you've all this gold sitting here, and that gold is really owed to us. We're legitimate creditors of the king. And back 1,000 years ago, in the early courts, you had courts of law and you had courts of equity. Equity meaning fairness. So, these folks that were owed money, they couldn't really bring a case against the king in the courts of law because they just couldn't for a variety of reasons. So they tried to bring the case in the main reason in Malta, they didn't have any contractual relationship with the people that had the gold. So they brought an action in equity saying, hey, it's not fair that you're holding gold that belongs to the king and we're legitimate creditors of the king. That's really our gold. We want it. And it's interesting that the courts back then went on to say that because the gold was put there for a specific purpose, to provide for the funding of the troops going and then the care for the troops coming back, it really had nothing to do with the legitimate. They weren't saying that the amount owed to the creditors wasn't legitimate, but it was completely separate and distinct, and therefore, they basically ruled in favor of the assets staying where they were with the Knights Templar, and that was really the beginning of the establishment of trusts. Interestingly, if you want to talk for just a minute about the civil law and foundations, you want to fast forward to the Napoleonic times. Napoleon did not agree with that earliest decision of the equity courts. Okay, so in that intervening 700 years, British law, common law, embraces this concept that you can have a trust that's a legal, juridical person separate and distinct from any of the parties. Right? If we go back to this this triangle. You've got the grantor, you've got the trustee, and you have the beneficiary. But the shaded area is the trust. And the trust is separate and distinct from all three parties. So how did that happen? It came out of thin air, didn't it? Right? I mean, it was done with legal documents, but it wasn't a contract. It's a gratuitous gift from the grantor to the trustee to hold for the beneficiary. And that triune, those interests coming together, creates this juridical person. Well, Napoleon thought that was a really bad finding. So when the Napoleonic Code was developed, and a lot of people don't realize, or they think that the Napoleonic Code was named Napoleonic Code because, he was the emperor at the time. No. Napoleon wrote the Napoleonic Code. And 95% of the Napoleonic Code in France is still law the way Napoleon wrote it with his own hand. So it wasn't just a general and an emperor. He was had a brilliant legal mind. But he didn't like this concept of trust, so he basically forbade the use of trusts in the French civil law. And it took another 150 years before the French and Spanish and Germanic civil codes were able to morph a foundation, which was basically a civil law version of a trust. And it's similar in about 90% of the ways. In some cases, it can function more like a company than a trust, which is why under U.S. law, you have what's called a check the box, where you can say, I've created this foundation, but for tax purposes, I want it to function as a trust, or I've created this foundation, and I want it to function as a company. I've actually heard people say, and heard people in conferences and read a few times, people say, well, there is no tax form for foundations, therefore foundations are not subject to U.S. tax. No, that's completely wrong. Somebody's going to end up with the orange jumpsuit if they take that approach. I mean, the IRS is saying, hey, you get to select which method, but selecting nothing is really not an option. All right, so that's a little bit about the ancient history of trusts.